I'm Jim Hendler, and I am the chair of the ACM's U.S. Technology Policy Committee. I'm very happy to welcome you today to our presentation talking about the origins, future, and various aspects of online content control and liability. This is obviously a pretty hot topic these days. In fact, just yesterday, Congress was grilling some of our friends from the social media world and other areas on exactly the topics we will be talking about today. Next slide, please. Just very quickly, next slide. I want to welcome you. I want to say just a couple words about the Technology Policy Committee. We are a subcommittee we are one of the committees within the Association of Computing Machinery. We have a number of different issues we look at. These are just some of the examples. Next slide. You can see here just some of the products we've produced over the past, well, back a slide. Some of the products we've produced over the past year or so. So statements about facial recognition, virtual meetings, an amicus brief regarding CFAA, the computer fraud. Can you please go back? Accountancy Act, and some stuff about to the Copyright Office. So we work together as a group of members of the ACM to produce these things. Now, next slide, Adam. I will not go through these, but if you want to consider joining, if you're an ACM member, I hope you will. The information is here, but easily enough, you can just look at USTPC on your favorite search engine, and you should be able to find us. And with that, let me have the great pleasure of introducing today's moderator, Andy Grosso. Andy is the chair of the law subcommittee of the USTPC, but he has a distinguished career. He was an assistant U.S. attorney. He was the chair of the American Bar Association's Institute for Cyber Law, and he's been a litigator in private practice in Washington since 1994, but he's really one of the experts on computing and the law. And with that, I'm going to turn it over to Andy to introduce the panelists and get things going. Thank you very much.
Thank you very much, Jim. Jim, of course, is from the greatest technological college on the globe, and that is Rensselaer Polytechnic Institute, where I got my technical degrees from. So if I'm a little bit biased, so what? That being said, I want to thank you all for coming today. It's not often that you get to see the topic of the talk you're moderating on the front page, or in the front, at least of the business pages of the New York Times, which I happen to get every day in hard copy. And there were two headlines. One was "Senators Take Aim at Mark Zuckerberg and Jack Dorsey" of Facebook and Twitter. And the other one being "Senate Committee Takes Sharper Aim at Facebook and Twitter." And under the captions, part of the articles were, "Democrats called for more regulation of the tech industry. Republicans homed in on bias complaints." So clearly there's a serious concern with how big tech platforms are affecting our political discourse and our system of government. The strongest comment came from Senator Richard Blumenthal of Connecticut, who said this during the hearings, quote, "You have built terrifying tools of persuasion and manipulation with power far exceeding the robber barons of the last Gilded Age. You have made a huge amount of money by strip mining data about our private lives and promoting hate speech and voter suppression." Well, you can see where he's coming from. at least if not the rest of the Senate, there are certainly some issues that will be addressed in the new Congress come in the new year. The statute that they're talking about is Section 230 of the Communications Act of 1934, which was inserted into that act in 1996 with a law known as the Communications Decency Act. Very briefly, it has two major provisions. The first generally provides immunity for website publishers for third-party content. And it reads, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. That has been such an important part of the development of the internet and internet commerce that those 26 words have been referred to as the words that created the internet. The second major provision of the CDA, or Communications Decency Act, is known as the Good Samaritan provision. It provides protection for or from civil liability for operators of interactive computer services in the removal or moderation of third-party material they may deem obscene, lewd, vicious, filthy, excessively violent, harassing, or, quote, otherwise objectionable, even if the material is constitutionally protected. So we have what I consider to be a very outstanding panel today. Danny Weitzner, who is one of the people who was involved in drafting the CDA back in 1996. Pam Samuelson of Berkeley, and Mark Rasch, a noted litigator. I'm going to introduce all three of them first, and then they are going to discuss for us different aspects of the CDA and where it might be going from this point onward. Before I do that, I want to remind you of a few things. First, this is going to be a recorded conversation. So you need to know that anything that you say here will be recorded for posterity. I don't know of any plans to distribute it, but I'm sure that at some point somebody may want to make a YouTube video out of it. The microphones will be muted, except for a few people, particularly the panelists. If at some point you want to ask questions, and there should be an opportunity, depending on how much time our panelists take and I take, for that to happen, please send to me, Andrew Grosso, the questions, and I will then unmute you and allow you to speak and pose your own questions. I don't need to remind anybody, but I will anyway. Cell phones off while you're speaking. There will be slides by the participants. Adam will have control over those slides, so you will hear, as you heard Jim do, ask Adam to move the slides forwards or backwards as appropriate. We may have journalists on this conference. Everything here is in background. If a journalist doesn't agree with that, please leave now, but we are welcome with that condition. If you are or have a need of closed captions, you can do that. There's a link to view stream at the top left of your screen, or there should be. And finally, I need to tell you that I'm working from home like most of us are nowadays, and I have 4 pugs in the house. So if you hear barking, it's not me, and I'll try and mute it before it gets too loud. With that said, I want to introduce our panelists. Danny Weitzner, who is currently the founding director of the MIT Internet Policy Research Initiative. I have known Danny since 1990, I think 4, when he was at EFF here in Washington, DC. And I started my own law practice here, and I met him through EFF. He was deputy policy director at EFF. He then became founder and deputy director of the Center for Democracy and Technology. After that, he was the Technology and Society Policy Director of the World Wide Web Consortium. After that, he was the U.S. Deputy Chief Technology Officer for Internet Policy at the White House, and he served there in 2011 and 12. Then he went to MIT as a principal research scientist and then director of the Computer Science and Artificial Intelligence Laboratory. And he is, again, still at MIT. And I want to thank Danny for taking the time to participate. Pam Samuelson has credentials that are outstanding. Fellow of the ACM, fellow of the MacArthur Foundation, professor of the University of California, Berkeley Law School and the School of Information. She is the chair of the board of directors of the Authors Alliance. And prior to going to Berkeley, she was also at the professor of law at the University of Pittsburgh. Mark Rasch is a personal friend of mine for many years. He is an attorney in private practice in the Washington, D.C. area with extensive experience in cyber litigation, forensic, and internet policy. He's a former trial attorney at the U.S. Department of Justice, Criminal Division, and he prosecuted the very first Computer Crime and Abuse Act case, that of Robert Tappan Morris, the Internet Worm case back in the late 80s. He founded the Computer Crime Unit at the Department of Justice. Among his positions in industry have been the Chief Security Evangelist at Verizon and the Chief Privacy and Data Security Officer at SAIC. By his own count, he has written more than 1,000 articles on cyber policy and related topics. I can't vouch for that. I haven't read them all.
Neither have I.
But I've read enough to know that he's written a lot. With that being said, I'm going to turn the video over to Danny. Please tell us about how the CDA came to be, what its purpose was, and what its actual role has been in the development of the internet. Thank you.
Andy, thanks so much. That's an inflated introduction. I'm really honored to be at this panel. My thanks to Jim and to Adam. It's great to see many colleagues and colleagues from all over the world. I do think this is an enormously important issue. And I want to just by revealing some of my prayers on this. First of all, I think that the CD has been extremely important for the growth of the internet, and I think particularly for people the ability to exercise their free rights online. I don't really claim the objective question, hope intelligent, but claim to be actually objective. Andy credited being in drafting of two, as people say, success. It had parents.
Danny, I'm going to interrupt you. Your audio is breaking up, and the suggestion has been made, as much as I hate to do this, to turn off your video, and let's see if the bandwidth allows the audio.
All right, about that. How is that?
Keep going.
Is that in at all?
I don't know yet. Keep going.
All right. Very sorry. See if I have a option up here. I don't. Okay. So let's see how this goes. One thing I want to hear in leading section 2, and can go to the next slide, please. It's certainly true on the one that when 230 was acted in 96, I don't think anyone really anticipated the scale of that the internet as a general would have on society. I do think there were very clear ideas, clear policy framework, a set of expression commitment, clear understanding of the strengths and weaknesses of current technology. And I'm some of those out short presentation suggests that think about change to section 2
Danny,
We also,
Danny,
yes,
you're breaking up at the end of your pauses. If that gives you any additional information, perhaps you could speak more steadily without long pauses. I don't know if that will affect your talk, but that may be a way to cure the problem.
okay. I'm very sorry about that. So just highlight some of the points that Andy made in summary of what security is. All of us talk about various aspects of security and how it works. I want to some of the arguments of the two provisions. As Andy, Section 2 fundamentally does things. It provides particular stack of what we commonly call platform, and it makes it internet platforms that those that we commonly have, such as Google engine or Facebook or Twitter, that they
Danny, I don't know about anyone else. It's not working too well for me. Here's what I'm going to suggest. Can we, and if either Pam or Mark is willing to do this, can we flip to one or the other? I would suggest Pam, but Mark would be fine. And then Danny, can you log out and log back in, and we'll slide you back in after Pam? Is that a yes or no answer? I don't hear anything.
Okay, let's give it a try. Next slide. Okay, this is, so I will give part of what Danny was going to say, which is that you have to understand that at the time that that Congress passed what became known as CDA, Section 230, it got folded into the Telecommunications Reform Act of 1996. And what they wanted to do is they wanted to encourage these new emerging services and platforms to engage in content moderation because the two cases that had been decided before this law got passed, one of them said no liability if you don't do any kind of moderation or any type of control. And then the second case basically said, well, but if you do any kind of editorial control, if you do, you say that you're going to moderate, then anything that's libelous or whatever is you're going to be responsible for as the platform. So Prodigy had bulletin board services that allowed people to have conversations about things. Somebody was charged with fraud on one of these bulletin boards, and Prodigy didn't know anything about it. But when the people that were libeled sued Prodigy, they couldn't get out of the lawsuit because they said, we're trying to be family friendly and we're going to moderate and get rid of bad stuff. And all of a sudden, any kind of editorial control would be actually put the platform at risk of liability. So Section 230 was really designed to say, okay, let's have people moderate. But let's relieve them of responsibility. If they themselves speak, they utter words, then they can be held liable for that. If they are directly acting as a publisher, then they can be held liable for that. But if the content is provided by a third party, there's no liability under Section C1. And
Pam,
that's,
in the interest of making this a discussion, you know, this is what's called the moderator's dilemma. They're damned if they do and damned if they don't. If they don't moderate, they might be held liable as a publisher or distributor. If they do moderate, then they may be an editor. And so this is what 230 was trying to solve.
it was basically trying to say, you know, but it wasn't, it was, oh, well, anyway, the next slide, please. So the very next year, the Fourth Circuit Court of Appeals basically heard the first really significant case. And what happened was there was a guy named Ken, and Ken Zaran basically didn't have an account on America Online, but somebody posted t-shirts for sale celebrating the Oklahoma City bombing, and a lot of people really got upset about that. And the ads basically said, call Ken, and gave his telephone number, and so people started calling up his number all the time and threatening him with death and all kinds of really terrible things. And he's going, I don't know what's going on here. So he gets in touch with a staff lawyer at AOL, and AOL says, oh, gee, we didn't know about this, but we'll look into it. And he was reassured a couple of times that they were going to take it down, and they didn't. And he kept getting these very, very terrible calls. So he finally sued them, sued AOL, and it wasn't suing them for defamation, but we're basically saying that AOL was negligent not to take down those ads after after being notified about how offensive they were and how much harm was happening to Zaran himself. So it was a sympathetic set of facts. Poor guy was, just trying to be a real estate agent, and all of a sudden was in a really terrible state. But what you have is the court basically saying, no, I don't care what kind of claim that Zaran is making, negligence as opposed to defamation. Congress intended Section 230 to shield these services from liability for third-party content. Next slide, please. So Congress, in the legislative history, it's pretty clear that they, again, this was at a time when tech was like growing and when people were really optimistic about the internet and so forth. So preserve the free market, promote the development of internet platforms, internet economy, avoid intrusive regulation. If you put too much liability on these services, then they will take down too much and censor people. And we want free speech to flourish on the internet. And we're going to trust them to moderate so that the community standards are maintained. And besides which, once these services get big, like America Online, there's no way that you can actually review every one of the posts. So it's this kind of scale issue. And even if you could review them, which you can't, how could you determine their legality? It's like you just can't do it. And so basically the court viewed the lawsuit that Zaran brought as a kind of evasion of Congress's intent to shield these platforms from liability under Section 230. And one thing to note is that if Zaran had won this lawsuit, then there would have been a notice and takedown regime in effect for all kind of content, not just for copyright. So there have been many, many cases, in fact, hundreds of cases brought against these various platforms over the 2 decades or so that it has been in effect. And almost all of them shield the content provider, or I'm sorry, the service provider from liability. Very, very, very small number of cases have gone the other way. But here are some examples of some of the, here's a couple of the cases that have been controversial. I'm not going to talk through all of them, but again, some of them had some very sympathetic facts. So Batzel versus Smith, another very significant appellate court decision. So Smith basically forwarded a libelous claim about Batzel that she had looted Nazi paintings, and her business, art gallery business, basically collapsed, and she was harassed so much that she had to leave the state and sell her property. And so, you know, her career and her reputation were really ruined by this thing. But Smith and others that simply forwarded the information weren't held liable at all. So another of the very controversial cases is Herrick versus Grinder. So somebody had a boyfriend that they broke up with, and the former boyfriend basically created a false profile for the person on this dating site and invited people to, like, oh, you know, come and have sex with me. And the guy was getting harassed. Okay. And would Grindr take it down? No. Even though it was a false profile. They didn't have any, they could have taken it down, but they chose not to. And some of these cases are really ones that people feel upset about, because maybe the liability immunity is just too broad. And so that's one of the reasons why people have been thinking about having some changes to it. Next slide.
Well, Pam, I just wanted to point out that the
Yeah.
liability is not just immunity from liability, it's immunity from being sued at all. And so if you can establish that you're covered by 230, the case gets thrown out even before the discovery stage.
Right. And that's the most important thing about it, which is somebody brings a lawsuit. The first response is, this is my defense is 230, case is closed. Okay. And again, with a lot of these cases, they have sympathetic plaintiffs, but the courts have basically followed this Zoran case quite intensively. So there are lots of cases, and defamation is common, privacy violation, revenge porn, harassment, even product liability cases have been gotten rid of, fraud by a third party, wrongful death. So one case that actually was a split decision by an appellate court. Supreme Court didn't take it, but it involved terrorists were using a platform to get organized, and relatives of this particular set of plaintiffs basically got killed by the terrorists. And so they wanted somebody to be responsible for it, because you can't sue ISIS, okay? But one of the things that I think is also, at issue here is that some of the platforms seem to encourage, or at least tolerate, and certainly have benefited from, you can say anything here, and as long as you say it, I'm not liable. So there's some irresponsibility by some of these sites, is what some people think. Next slide. Okay, so who's upset? Everybody's upset, practically, except Ron Wyden and Christopher Cox, the two people who devised this thing in the first place. So both Joe Biden and Donald Trump have called for the repeal of Section 230. There isn't a repeal bill pending before Congress at this moment, but there are at least 11 bills in the Senate and 10 in the House. Now, some, but not all of them, are overlaps. That is to say, the same bill gets introduced in the Senate and in the House. But I mean, we're talking about 15 different bills, and I'll talk about in a minute some of the different dimensions of it. And the Department of Justice has also offered its proposed legislation. There's a link here. Now, the thing is that the Republicans are mostly upset about Section 230 because they believe that the platforms are taking down too much, right? So if I want to sort of say this disinformation, blah, 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 a lot of times the platforms will take that down, or will flag it, or will somehow kind of demote it. And they think that shows that they're biased against against conservatives, and you're censoring me, and that's terrible. And Democrats are mostly upset because they think the platforms aren't taking down more. They want them to take down more. And so what you have is, you know, people who agree on a principle, but not at all about the substance. So hate speech, disinformation, cyberbullying, and concern that the way the algorithms work is that it promotes more extreme content, that people are more likely to click, right? User engagement is about getting people to stay on, getting them engaged, and the more extreme the content, the more they click through. And so
just to point out, remember 230 was designed to immunize providers or carriers for other person's content. And now you get into this whole idea, what is the role and responsibility of social media for what they purposefully do and their algorithms and stuff like that.
Right.
So that's one distinction between other people's content and what the carriers actually do.
Right. So there are a lot of different approaches to Section 230 amendments. So some of them would make the platforms spell out their content moderation policies with particularity in their terms of service, and you can only take down something that is identified in your content moderation policy in your terms of service. Some of them, again, these are more the conservative bills. Some would basically say, if your content was taken down in bad faith, that is to say, you think that you were censored, you can bring a lawsuit and you can get $5,000 for the harm to you for your stuff being taken down. Next slide. So there are 3 types of conduct that platforms don't get 230 immunity for. So one is copyright and intellectual property infringement, but copyright is the main deal here. 2 is for, I think, federal criminal activity that happens, and 3 is facilitation of sex trafficking. That was an amendment that was the third one was added by an amendment a couple of years ago, because some of these sex trafficking sites were basically, you know, saying, "Oh, I'm not liable," and people said, "No, actually, sex trafficking is really bad." So there's suggestions for more things to exempt the platforms from the 230 immunity, and some bills would impose due process requirements on the platform. So you can't remove the content unless you know, you give notice about it and give the person a chance to respond, etc. Right now, almost all the platforms in their terms of service basically give themselves complete, absolute right to take down anything for any reason, and we don't have to say anything. We don't have to explain anything to you. We just take it down. Boom.
And no duty to take it down.
And
they have
no
the right
duty
to take it down,
right.
but no duty.
No duty to take it down. So I get to make all the decisions, is the kind of the platform's view about these kinds of things. And there's at least a couple of bills that seek to regulate algorithms, hoping to stop the spread of extremist content or eliminating bias. Next slide. There are also some proposed reinterpretations of Section 230, and I won't say too much about this because I know Mark is planning to do it, but Justice Thomas of the US Supreme Court decided to publish a statement in connection with a Section 230 case that was before the court on a petition for certiorari. The court decided not to hear the case, but Justice Thomas basically said, "Oh, this 230 stuff, let me invite plaintiffs who lose on some of these cases to appeal to the Supreme Court, because I'm willing to basically reinterpret the immunity provision. So if you remember, C1 basically talks about that these services will not be treated as the publisher or speaker. It doesn't say anything about distributors. Now, distributors have a different liability, right? If you're the speaker, you're the wrongdoer. If you're a publisher and you say, I'm gonna let this speaker get to a wider audience, you are definitely as liable as the speaker is. But distributors basically only have liability if they know, or at least have some reason to know, of the wrongful content. So Smith versus California was a case about a guy who's running a kind of an adult bookstore that also sold chewing gum and candy, and there was a book in his shop that was deemed to be obscene, and he was convicted of a violation of an LA ordinance, and the case went all the way to the Supreme Court. The Supreme Court said you can only hold somebody liable as a distributor if they know. Did this guy know? Guy didn't even practically read. He never read on any of the stuff in his stuff. So he's anyway. So Thomas basically says, hey, we can basically say distributor liability. So once you get notice, essentially, you can be held liable if you don't do something about it. Next slide.
And within distributors, there's two kinds of distributors. There's regular distributors and there's common carriers. And common carriers typically have statutory immunity for what they distribute.
Right. Thank you. As you know, President Trump issued an executive order, and he did that 2 days after Twitter tagged one of his tweets about mail-in ballot fraud, and he didn't like that. He thought it was censoring him, so he issued this executive order. Next slide. There are some things that the president can do and some things the president can't do. So one of the things he can do is tell an official within the executive branch. So NTIA is basically a subpart of the Commerce Department. So he can say to the Commerce Department, submit a petition to the Federal Communications Commission and tell them that they should engage in some rulemaking about Section 230. He can't tell the FCC what to do because the FCC is an independent agency, but 3 of the 5 commissioners can start a rulemaking. And the chair of the FCC has said that he intends for the FCC to do this. The president can also tell the Attorney General draft legislation and do various other kinds of things. He also asked the Federal Trade Commission to investigate social media platforms, saying that they're engaged in unfair and deceptive trade practices, and nothing much is going to happen with that, I'm sure. He can also direct the Office of Management and Budget to review U.S. ad agency expenditures on platforms and basically say, we'll cut them off financially. Next slide. The NTIA did as requested and issued a petition to the FCC. So they are making the argument that there's a difference between C1 and C2 that is now ambiguous, and so a rulemaking could clarify that C1 is about getting immunity for what you keep up, and C2 is about a limit on what you can take down as a platform. Next slide, please. So C2 is basically now being interpreted. So right now it says that anything that's otherwise objectionable, the platforms can take down, and the NTIA says no, that's not true. It has to be similar to obscene, lewd, excessively violent, harassing, or it doesn't fit within this immunity provision. So if you take down, for example, disinformation, that's going to be not something within the you're not covered by this particular immunity. And also, you can't say that a takedown's in good faith without due process protection. So these would be very significant changes. Again, with the change of administration, this may not go anywhere, but it will depend at least on whether the chair of the FCC could get 2 other commissioners to go forward with the rulemaking. But that's kind of where we are with that. I think I'm done with that now.
Yeah, and just to put that a little bit in context, what they're basically saying is that the act of taking something down or not allowing it to be published, what that does is that becomes an editorial act, and you don't get immunity for that editorial act unless you are doing it within certain very limited strictures. So it has to be, essentially, you can take it down if it's criminal or something like criminal or subject to some pre-written policy. Otherwise, you don't get immunity for taking it down. And that's really goes to that whole debate that Pam was talking about the difference between the Republican attitude about these social media sites and the Democratic attitude. And the Republicans say, you're taking down too much, we need to restrict what you take down. And the Democrats saying, you're allowing up too much, we need to restrict what you're putting on.
And for those who follow net neutrality, just by the way, there's something that's just ironic in the extreme about the Republican administration, the Republican Congress, and the Republican FCC, which started off this administration by declaring that the FCC had no authority to regulate the conduct of broadband internet service providers because the Communications Act didn't give that authority. Now saying that somehow the FCC would have the authority to regulate at a much higher layer, as it were. It gives you a little bit of regulatory whiplash if you try to follow.
Yeah, I think Dan's absolutely right there. And the other issue that relates to this is the idea that the more that you impose liability on these third parties, these social media networks, for what is on there, the more they're going to have an incentive to regulate content and take stuff down. So if they have liability for allowing something to happen, they're gonna take more stuff down.
Speaking of net neutrality, is my service back to something tolerable?
Yes, we can hear you.
Okay, that's great. I'm very glad. I feel terribly. This is the first time this has happened in like 9 months of Zoom.
I think you're being censored by Zoom.
I have no doubt, or someone in the middle who we don't even know about. That's right. Should I just? I'll dive in really quickly here, and because Pam taught you about Zerin, you really know the basics and the most. The sort of high level of congressional intent, because Zerin really was, I think, did work very hard to try to hew very closely to what it thought Congress was doing in enacting 230. What I want to do is just go over in these 4 categories exactly what Congress did, but I want to start by stressing a little bit about the significance of designated what we call the internet platforms now as these, in the words of 230, as information, as interactive computer services, and as free from publisher liability. This actually, as Mark alluded to, has a long history to it. So in some sense, in designating the internet platforms as being free from publisher liability, it really placed them in the tradition, in the model of entities that facilitated commerce and facilitated speech, but did so largely in a neutral manner. So it placed them in the category of printing press owners, almost of ferry boat operators, of traditional common carriers who were, except in very, very unusual circumstances, not responsible for any harm that was done through the use of their services. It was understood at the time that these internet platforms were in some sense neither fish nor fowl. They weren't the underlying network operators, they weren't the telephone companies or the internet service providers, but by the same token, the goal was really to make sure that they had a lot of the protections that we've traditionally accorded to carriers. So again, because you now know about 230, what you know is it really operated, I would say, on 4 levels. And I want to just go over them and then quickly illustrate, I think, some of the questions that we have to ask in each of these 4 categories as we think about potential for reform. First of all, obviously, Pam, I assume you talked just a little bit about the corrective that 230 offered to this one particular case, Stratton Oakmont. Has that been covered?
Yes.
It was touched on, yeah.
Great. So that was simply to correct the designation of one of the early internet platforms, Prodigy, as the publisher of content, where they claimed that they were merely the distributor. Congress decided that needed to be fixed. But what I want to stress is that there were much broader goals than just fixing a kind of a legal mechanism here. Congress was seized with the challenge of what to do about the fact that a lot of objectionable content, sexually explicit content, and other kinds of content was available to minors and even was available to adults who found it offensive. And Congress really faced a kind of a fork in the road and said, are we going to subject the internet to censorship, to content control, the way we had done for the broadcast media, for radio and television, or are we going to do something different? And 230 marks a very concerted decision to rely on user empowerment, on technologies that enable people to make choices about what kind of content they were going to see or not see, or what kind of content their kids were going to have access to, not put those decisions in the hands of government. That was part of a larger or related deregulatory move. As I think Pam said, this law was passed by Newt Gingrich's House of Representatives. It was part of an early, really substantial deregulatory move. And there was a very clear preemptive effort to put the internet, not internet access providers, but the internet platforms, into a category that was largely going to be deregulated and certainly not regulated at the FCC, hence the irony of the NTIA petition.
It also reflected a philosophy that the answer to bad speech is more speech.
100%. There was an important set of technology assumptions behind 230 as well. There was an assumption that if you made the platforms, in 230 terms, the interactive computer services, responsible for all the speech that flowed through those platforms, the platforms would simply grind to a halt. That the ability to filter content at the scale that it was being placed on the platforms was simply too much for technology at the time. But by the same token, there was a kind of an optimism that various kinds of technical tools, content filtering tools, could be used by individuals to try to tailor their internet experience, to make sure that they and their kids only saw things that they wanted to see and avoided things such as sexually explicit content that they didn't want to see. There was software, this little company, Surfwatch, there were a bunch of others. And the way they worked, by the way, is they actually employed hundreds of students, graduate students and others, who would actually go through and manually tag one URL after another. And that's how content filtering worked then. There was an important assumption, which is worth questioning now, underneath this technology-centered approach, this user empowerment approach, which assumed that there would be lots and lots of platforms, and that more or less anyone could find a view of the internet, if you will, through their platform that was consistent with their values. It was in the late 1990s, there were over 7,000 internet service providers and web hosts, and Mark and others will remember this.
And then part of this was the magazine model. You know, like you go to the magazines,
yes,
you would have magazines dedicated to anything. And
absolutely.
This follows on the bulletin board model that predated.
100%. Yes, 100%.
So the idea was you would have an internet for children, an internet for adults, an internet for young adults. You'd have a different, and of course they had no way of knowing what would actually happen.
Right, and I would say as a civil liberties advocate, at the time who was trying to urge this approach on Congress, I was really excited when, for example, a Mormon owned software publisher got in touch with us and said, hey, we've got a filtering package, because that's actually what we were hoping for, was that there would be all these different views that would create a diversity of voices, the ability to make choices individually and not have to rely on government censorship to make those choices. And that's what the Supreme Court said in 1997 when it threw out a big part of the act that the congressional act that contains Section 230 in the ACLU v. Reno case. And here I just want to stress that you'll hear a lot about 230 and the value it's created for a lot of big companies and small companies. But for me, at least, and I think for the civil liberties community, 230 was fundamentally a free speech provision. It was fundamentally a guarantee that that people who wanted to speak through the internet would be able to find a platform where they could do that. And most importantly, that the platforms would not feel incentive to censor speech. That there would, because what we recognized was that, though, as the Supreme Court said, the internet was this whole new medium of expression that deserved the highest level of free speech protection because it was so pro-democratic and pro-free speech. At the same time, we knew that users were dependent on these platforms to speak and dependent on these platforms to hear the speech, to receive the speech of others. So we had to make sure that the platforms had minimum incentive to restrict speech. We knew that we weren't going to be able to argue that the First Amendment somehow prevented platforms from editing speech. In fact, the First Amendment probably protects platforms who want to edit speech. But we had to create an environment that was as open as possible, and that was dependent on having platforms that were really open. Next slide, please. Let's go to the next one, just in the interest of time. A point of the previous slide is 230 has been responsible for really literally trillions of dollars of economic value, and has been part of a suite of internet policy provisions that led to billions of people having access to these kinds of services in a relatively rapid period of time. I might have included the DMCA on this slide, but I didn't want to pick a fight with Pam or Adam or anyone else. That's for another discussion. Now we have all these reform proposals as Pam has outlined for you. And I think we have a bunch of questions we have to ask. There are real questions of law. Is 230 impeding justice, criminal investigations, or civil liability that really should be imposed? It's notable that at the same time as, right around the same time that Congress made some amendments to 230 in order to supposedly limit the ability for platforms to hide behind 230 in service of what is really reprehensible human trafficking activity. At the same time, prosecutors were able to shut down services like Backpage, which claimed the protection of 230 for advertising for essentially sex slavery. But in fact, they were able to be prosecuted anyway. But we have to look at, is there injustice done because of 230? That's an important empirical question for us to ask. Secondly,
I just want to say one thing. The whole point of 230 was to say you don't go after the platform, you go after the speaker. And one of the problems we have developed over the years is the speaker is increasingly anonymous. And so if you can't go after the platform and you can't find out who the speaker is anybody liable for
Right.
this kind of speech?
And what we found in a lot of these cases, as you know, Mark, is that it's true that you can't go after the platform, but if you have someone who's, for example, facilitating the exchange of money, you can go after that person. And
Right.
that's, of course, what happened with Backpage, which was a kind of an extreme version of Craigslist that was really existed for advertising and facilitating sex slavery. Just let me go through the rest of these, and then I want to turn it to Mark. I think we have some policy questions to ask. Is user empowerment still going to be the way that we're going to go in terms of real questions about what kinds of content, potentially harmful content, is available to people in society? Or do we actually think we could replace that with something? Do we actually think we could start regulating speech that is constitutionally protected, but still somehow harmful? We do that for radio and television, but that's a much more constrained medium and a medium that has many fewer speech opportunities for people. And if we are going to create rules about content, whether they're, as Pam and Mark said, whether they're about what content you have to keep up or what content you must take down, who's going to make those rules? It's one thing to look at, a lot of the cases that Pam mentioned, where there are, results that may not seem totally satisfying, situations that Mark mentioned. But if we're going to really change the fundamental arrangement here, the question is, where are these rules going to come from? And we have to be serious about what those answers are. From a technical perspective, I think this is especially important for the ACM. We ought to take a careful look at the technology environment for content moderation, for managing content, for assigning accountability, for things like that. As I said, when 230 was enacted, there were these very kind of quaint little manual content filtering tools that would maybe block out some of the URLs of sexually explicit websites. But by the year 2000, Google had deployed very sophisticated, for the time, neural net technology, machine learning technology, that is now what is called safe surf. So now Google search results and search results from Bing and other search engines that are out there do very sophisticated, automated, machine learning based filtering of content. And we should ask the question: are those working well enough? Are they over blocking? Are they under blocking? Do they have bias in them that we worry about? But these are empirical questions that we can really ask, and we really ought to look at, because if we keep 230 in place, part of what we're saying is we're dependent on the platforms, as has been said, to manage, to categorize content so that it can be sorted out by people as they want. We got to ask whether that's working well enough.
From a technology standpoint, and I'll eat into my own time for this.
Yeah.
One of the problems is technology has been changing. So there was, before the advent of social media, I could stand up my own web page, which would be hosted by somebody who knew nothing about what content I had on my website. So there was really nobody controlling my speech except me. When you're talking about social media, I am subject to the terms of service and terms of use of the social media platform. So it's a fundamentally different relationship that I have technologically, not just legally, with the other people online. And
right,
so,
and the same is true for search engines. The Google search engine is a substantial filter on the content that is seen. It used to be, this kind of neutral window. It's now far from neutral. And that is, in a certain sense, the result that 230 anticipates. And the final thing I'll say, and then I want to hand it over to you, Mark.
Sure.
We should remember that 230 still is a critical element of our free speech protection framework for the online environment. We look at the democratic process now, and it seems very ugly, and there's a lot to worry about in the kind of conduct that we see on the social media platforms. And we'd like to say, well, if we just change 230, somehow we could fix all that. I think we have to look at that really carefully, because we have to look at what would be the alternative source of rules, besides, as Mark says, the quite in some cases arbitrary and often non-transparent decisions that the platforms make. And finally, we have enormous market concentration in this environment. There is effectively just one search engine. There is effectively one online marketplace. There are effectively only a few social media platforms. And so the environment, the way that 230 was going to facilitate the key First Amendment goal of having a diversity of expression, I think is really now under some question, because we just don't have the diversity of platforms that I think we thought we would. But what we do know, and I'll close on this, is that users depend on platforms as conduits for speech. There's no free speech on the internet without these platforms. That puts a lot of pressure on 230 in a funny way in both directions. We worry about maybe restrictions that go too far and restrictions that don't go far enough. But this really should be viewed as a general question about free expression as we think of any kind of reform effort. So my apologies again for the early technical glitches, and I'm looking forward to hearing Mark.
Thank you, Dan. And by the way, one other thing that you just reminded me of is, we think about these 230 as protecting web pages and social media, but then you have to think about search engines as search engines are actually acting as you said, as a filter. And then the question is, what's the liability of the search engines for delivering results or not delivering results? Because they also facilitate individuals' access to content, which can include objectionable content. All right. So I think before I begin on the slides, I think one of the things that we've shown here is that we want to promote free speech. We want to promote free expression. We want in some way to promote responsible free speech. And I think one of the downsides of the way Section 230 has been applied is the idea that I could set up a website or I could set up a platform where it's my desire to actually cause harm to people. And I can injure people's reputations, do all kinds of malicious things, and nothing can happen to anybody. And I think that's one of the problems, is how do you balance the right of free speech and the duty of responsible speech? If you look at the legislative history of 230, if you look at the statement of purpose of 230, the statement of purpose is to promote as much open access and speech as possible. And I think that's pretty much what it's done, for good and for ill. Okay, next slide. So one of the things that's happened now, we had these hearings yesterday, and the whole idea behind the hearings, and you saw how partisan the hearings were, is it reflects this divide about the nature of the problem. The conservatives and the right wing see that the problem is the censorship by big tech, and on the left and by liberals and Democrats, the problem is that there is too much content, harmful content up there. So it's not enough censorship. And so when you start out with the idea that you have two different people with two different problems and two different perceptions of the problem, you're never going to get to a solution that will make either of them happy. Next. So what has happened now is, in September of this year, in the lead up to the election, and that's not a coincidence, the Attorney General's office came forward and they came up with their own proposals for how they wanted 230 to be amended. I'm going to go through a couple of them very quickly so you can see what the administration is proposing. And I think this goes in very well with what Pam was talking about, where she was telling you about the philosophy behind regulation of internet providers and these third-party non-content providers. Next. And again, this goes to the whole idea that what you believe is the problem will dictate what you believe is the solution. So we'll go now next to the next slide. So this was on September 23rd, 2020. This is a link to the site, and it puts limits on Section 230 immunity. One of the things that the Attorney General addressed specifically is this idea of using algorithms to suggest and promote content to connected users, and that these providers can abuse this power by censoring lawful speech and promoting certain ideas over others. Now, you notice the way it's phrased. The problem with algorithms is that it censors speech and it promotes, in this case, liberal ideas over conservative ideas. I think if you were to talk to liberals and Democrats, they would say the problem with algorithms is that they push people down these rabbit holes, which promote conspiracy theories, hate speech, and the like. So again, even the use of algorithms, both parties may see this as a problem, but they see it as a fundamentally different problems, which require different solutions. The Attorney General also said that 230 immunity goes beyond mere defamation immunity, but it can be invoked even where a provider knows their services are being used for criminal activity. So as a result, the solution that the Department of Justice proposes is to make internet, these third-party providers, liable for the criminal conduct or the promotion of criminal conduct by third-party speakers. Okay, we'll go to the next. So right now, the scope of the immunity, and I see we all picked the Wolf of Wall Street case, comes from Stratton Oakmont, which we've talked about a number of times. And in Stratton Oakmont, very simply, somebody posted something on a message board saying that Stratton Oakmont were a bunch of crooks, not like they would ever make a movie showing that Stratton Oakmont was, in fact, a bunch of crooks. Stratton Oakmont, rather than suing the publisher, the person who posted that comment, sued Prodigy. Okay. So basically, what 230 says is you're not treated as a publisher of third-party content. You have immunity for good faith moderating. And I use the word good faith because one of the things that the proposed legislation does is it tinkers with the definition of what is good faith. It provides immunity from liability and immunity from litigation. And one of the problems you have is when you start tinkering with 230 to create exceptions or exclusions, now you get to litigate those exceptions or exclusions. And now the cost of litigation, these providers now, like Facebook and Twitter and others, are going to spend millions of dollars in litigating the fact that they have immunity, something that they already do, but at least they get summary judgment. The more things you add to 230, the higher transactional costs you're going to put on these providers, okay? One of the things I want to point out, something that is ambiguous under Section 230, is whether or not these third-party providers have liability under other theories of liability, like aiding and abetting, criminal facilitation, conspiracy, or misprision of a felony. Now, there have been lawsuits in which those have been alleged, but where the third-party provider, like Facebook, knows that it's criminal conduct and intends to facilitate that criminal conduct, I think you might have an argument that the provider is then now conspiring with the speaker to facilitate and promote the criminal conduct, and you may have liability under a statute like 18 U.S.C. 371. The same thing is true for criminal facilitation. These are separate statutes outside the scope of 230 immunity. You're not going after the provider as a publisher. You're saying you are working with this person to actively do this. You have the same criminal intent, and there you might have liability. The reason I mention that is if that is true, then there's really not a need to change 230 immunity. You just need to change the theory under which you would be going after these providers. Okay, next. So one of the things the proposed statute does is it wants to redefine what constitutes a content provider. Right now, the content provider, that's the person who does have liability, is the person who created the content in whole or in part. DOJ wants to add to that anybody who solicits, comments on, funds, or affirmatively and substantively contributes to, modifies, or alters information provided by another person. Basically, this would reverse Zaran. This would also reverse, reinstate key elements of the both Cubby versus CompuServe and the Stratton Oakmont case, because the act of soliciting, commenting on, altering, modifying the information would make you the content provider. So it basically says if you edit it, modify it, contribute to it, you become the speaker rather than the distributor. Next.
Mark, could I just add one really quick point on the solicit? Sure. You know, I don't think you mentioned, Pam, Pam, did you mention the roommates case?
No.
Because I think that's an interesting kind of counterpoint. So that's a case in which in the end, there's a web service that matches roommates to each other, and the service was ultimately found to violate fair housing laws because it asked questions about the race and gender of the individuals who were trying to get matched. They claimed 230 immunity, saying, well, no, it's the person answering the question who's providing the content. And Judge Kaczynski actually said, to the contrary, no, you created the environment. You're not just the platform. You're actually a participant in that. So that's one example of a case where there have been limitations found on 230 liability already.
Right, and in fact, that case is cited by Justice Thomas in the Malwarebytes case. Okay, he relies specifically on that. All right, so the stuff in red is the stuff that they propose to change. One of the areas in Section 230C is the C1, B, and C, that these providers would have no immunity for a decision to restrict access to or availability of material provided by another information content provider. So basically, they're saying if you decide to restrict access, okay, if you that's an editorial function for which you have liability, unless you do it pursuant to a stated policy that you have published and the like. And I'll talk about that in just a
Mark,
second.
can I just interject here?
Sure.
One thing that we haven't talked about yet, but that I think is very important, is the First Amendment. So these platforms actually have a First Amendment right to decide what is on their platform or what they don't want on that platform. And so tinkering with 230 doesn't alter the First Amendment challenge that could be made if somebody took down disinformation or took down hate speech or took down some threat. That's something which, even if it's not in your term of service, I think that based on what I know about the First Amendment case law, 230 is a reinforcement of free speech rights, but by itself, tinkering with 230 doesn't change the First Amendment landscape. Platforms are still going to have First Amendment arguments to be made.
Right. And one of the interesting things is within the First Amendment, you have a whole bunch of case law that deals with what is speech and what is non-speech. And so restricting non-speech under the First Amendment is also protected activity as well. So basically what they're saying here is, remember, this is a GOP proposal. So what they're concerned about is people editing and limiting them. So they said, well, you can restrict access to specific material that you have an objective, reasonable belief violates your terms of service or use. But if you restrict other stuff, then you're going to be liable essentially as a publisher of the stuff that you've allowed to be published. So you get liability for taking things down, okay, which is directly contrary to the way 230 works right now. And that's what Pam was talking about when it says, or other objectionable material. The carrier gets to decide what's objectionable according to whatever it wants. This would restrict it and would require them to set out specifically what it's going to restrict. One of the problems with that, and we should be concerned about this as an organization, is, for example, if you say we're going to take down disinformation about the election during the election, well, is the election still going on or not right now? We don't know. So there's no way you can have language in a terms of service that are so specific as to define what it is you're going to take down, because often you only know it when you see it. Next. So this was the whole idea about taking down availability information that you consider to be obscene, lewd, or lascivious, right? This is what they wanted to have taken down, and this comports with other parts of Section 230. Now, it's not enough that you believe that it is obscene or lewd. You have to now show you have an objective, reasonable belief. And again, this goes with the whole philosophy that they don't want you restricting content, particularly of conservative speakers. Okay. Now, remember the part that said otherwise objectionable, that gave these providers broad leeway. Now they say promoting self-harm or unlawful. So now it doesn't have to be objectionable. It has to be actually unlawful for you to be able to restrict it.
So if Fox all of a sudden bought Facebook, this might be a different, you might look at this differently, right?
Well, let's not forget that Fox owned MySpace.
Right. That's right.
They did. Okay, they did buy MySpace for exactly that reason. And by the way, if you take a look at Parler's terms of service, Parler says it will take down content if it is illegal, promoting illegality, or if it promotes any tortious activity. So in a way, Parler's terms of service are much broader and give them much greater ability to take down content than does even Facebook.
All right, I have a question.
Yeah.
I'm looking at this amendment, quote, has an objectively reasonable belief. And I'm looking at promoting self-harm or unlawful. That's fine if you've got a human being sitting there looking at the conversations. We have algorithms. We have neural networks. How are we going to enforce those standards?
Oh, you want answers?
Yeah.
Well, the answer would be, if I were trying to enforce this in the Justice Department, I would say that your algorithms are designed to look for this type of content, and here's a kicker, and nothing else.
A neural network?
Again, you have to go back and test the neural network to make sure it's not over editing.
Yeah. I mean, I think the designers of safe search, or perhaps some of these machine learning facilities that detect child pornography, things like that, presumably they would say, well, we trained it on child porn images. We may not know everything about how the neural net works, because you can never know everything about how a neural net works, but here was our intention. And I guess that would be the argument you would have to make, right?
But one of the problems here is promoting terrorism. Does that include right-wing extremism, violent extremism, gun rights activity, things like that? These are judgment calls. And these are judgment calls that are initially made by the platform. What kind of environment do we want to create for our users? This is directly antithetical to what Dan was talking about, the whole idea of everybody having a channel. And if I want to have a channel in favor of violent extremism, I should be able to have that channel. Now, if I'm promoting violent extremism by having that channel, I should have criminal liability for what the channel, are promoting, not what other people are promoting on my channel.
All right, next.
Now they create something called a Bad Samaritan. We have the Good Samaritan law. Now we have a Bad Samaritan law. And this is that if the provider acted purposefully with the conscious objective to promote, solicit, or facilitate material or activity by another information content provider that you knew or had reason to believe would violate criminal law, and then you disseminate that information, you lose immunity. Now, as I pointed out before, once you are actively soliciting criminal activity from somebody else or criminal information, I think you lose the liability under a aiding and abetting, criminal facilitation, or conspiracy theory anyway. So I'm not sure that this is necessary. The problem with putting this in is you have websites like don'tdatethisguy.com. I remember that from years ago. And this actively encouraged spurned women to post information about how bad their ex-boyfriends were. And oftentimes, and the men who were the subject of this believed that they were being defamed. All right. And they went after the platform, saying the platform actively encourages people to post this kind of stuff. But there's a difference between providing a forum for people to do something and the people who do it. That's the whole philosophical basis of Section 230. So I don't know what to do with this section. You can reasonably debate it. I think that if you're actively encouraging people to violate federal criminal law, the other problem is this: there's over 4,000 federal criminal laws. Okay, from everything from painting fences to how we treat wildlife, to letting pigs run wild, and how we label cheese. To make these platforms liable, criminally liable and civilly liable, for postings that other people make that encourage the violation of federal criminal law is, again, a huge problem. Next slide.
I'm going to interrupt for just a moment.
Sure.
You mentioned aiding and abetting, which is Section 3 of Title 18 Criminal Code. Section 4 is misprision of felony.
Yes.
And there you have to have actual knowledge of the felony having occurred.
And you have to have either you have to have failed to report it.
Yes. And
So now if you have an algorithm that searches out this criminal activity, you can say that the provider has actual knowledge because the algorithm works. And therefore, when they fail to report it, they can be criminally prosecuted.
Could you give us an example of how that statute might actually come into play? Just a simple example.
Let's say, for example, that you are the chief information security officer of a car transport company that picks people up, like a taxi cab service, and you learn that you've had a data breach, okay, and you pay off the hackers as part of your bug bounty program because you know that you've had a breach, okay, and you pay off the hackers and tell them, listen, I'll give you some money if you go away and don't tell anybody about it. Now you have actual knowledge of the commission of a felony against you, and you have concealed and failed to report it, and therefore you may have liability for misprision of a felony. Does that case sound familiar to anybody? That's what he was charged with in the Uber hack case. Okay, so you have to do two things. You have to have knowledge of a felony, any felony, federal felony, and you have to have concealed and not reported. You have to do both.
The problem that you have with that proposal is, what do you mean by had reason to believe?
Right.
Most people not only don't know all the facts, but they don't understand the law.
And the question is, do you have to know that the conduct occurred, or do you have to know the conduct occurred and also know that it would violate criminal law?
All right, we're running out of time.
Next, I'll go quickly. All right. So this goes to the whole question of actual knowledge of criminality. You lose immunity if you have actual knowledge. There's a difference between where somebody knows or when somebody tells them that it's a crime. And one of the problems is I can remove immunity by just telling you, hey, that's a crime. Do you have to believe me or not believe me? That's another question. All right. And it requires them to remove the data, report it to law enforcement, and preserve evidence about it for a year. And this, again, is the idea of making these providers agents of law enforcement, okay? This goes to the whole idea that we were talking about before, about the difference between how 230 works and how it works for copyright information. Now, if I get notice, I have to take it down. Next. Some other things, if a court orders me to remove content and I don't remove it, I have liability now as the publisher of that content. There's no immunity from federal regulatory actions, including FTC. So I can be treated as the publisher of other people's content for federal regulatory purposes. No immunity from liability for terrorism, child porn, federal or state cyber stalking laws, and they threw in, for good measure, antitrust liability. And then in order for me to act in good faith, I have to adhere to prior published policies, and I cannot deviate from those. Next. All right, this is the last. We'll talk about Clarence Thomas's opinion in the malware bites. This is October.
Mark,
yes.
I already covered that, and we are 5 minutes from what is supposed to be the ending of this. Sure. Andy, I think it's probably time to go to questions.
Well, I'm going to let Mark just finish up very, very briefly.
No, just go forward.
All right, we have
forward
a number of questions. And I'm going to ask in order of the ones that have come in. And forgive me if I mispronounce your names. Well, you don't have to forgive me, but.
Okay, we can stop sharing the slides, by the way.
Okay, I'm going to unmute Carl Landwer. You had a question, and I'm going to let you pose it.
Thank you. And I really enjoyed the discussion by all of you. I'm just curious, all these companies are international. They're distributing stuff internationally. What's protecting them overseas? If there's somebody sues them in a French court or a German court?
The answer is much less, Carl. And the answer is there are many countries, for example, YouTube regularly has to take down videos in places like Pakistan because they're not because they're copyright violations, but just because the government says that defames the prophet or violates some other public morality rule. In Europe, the situation is a little more nuanced. There is a version of Section 230, which is known as the e-commerce directive, but courts have been have treated it as kind of just one factor to consider. So platforms have been found, for example, to be liable for a number of privacy violations, even though in the US, probably 230 would have protected them.
So it's important actually to understand that the European Union member states actually have a very different conception about freedom of expression than we do with our First Amendment. They have adopted some pretty strict regulations actually about terrorist content, about hate speech, and about other kinds of harmful content. And they are working with the platforms to basically make them report what they're taking down and what they're leaving up and about their policies. And they're trying very hard actually to promote good freedom of expression and to try to stop bad stuff. So they actually have no equivalent really to 230. They have a notice and takedown regime for all kinds of unlawful content. And so I think, there is an argument that many people make that 230, the reason that we have the most thriving internet commerce companies is because of 230, because startups can basically get going and they don't have to worry about this kind of liability. In other countries, they don't have this equivalent. And so 230 is really important, especially to small and medium-sized companies. And right now, the European Union seems to have given up on having a kind of a vital internet commerce thing. They're basically working with Facebook, working with Google, working with others of the major platforms to try to basically nudge them to do more takedowns, more takedowns, more takedowns. So that's actually a very big difference between the US and other countries.
Andy, let me interrupt just for a second. On behalf of the ACM, I want to let people know that they're graciously giving us another 10 or 15 minutes since we seem to have plenty of people who still want to participate. Those who must leave or wish to leave, thank you so much for your time. And I'm going to thank the panelists now officially, but since it's the end of time, but we'll keep going for a little while more, assuming they're willing.
Happy to do it.
All right. Michael Lesk, you asked a question that I thought was interesting. And let me see if I can unmute you. There you go. Michael?
Okay, so I have a different proposal, which is that it was a mistake to allow anonymity, and we should try to end it. We should say to platforms, if you publish something without a name and address, then you wrote it and you're liable. I know this about Hong Kong Democrats. And the traditional answer in the newspaper world was anonymous letters to the editor got published after consideration by the editorial staff, and that the editorial staff had to know the actual name and address. My view is that this would at least dispose of the huge number of Russian bots on Facebook. And it's not clear to me why it is so essential to allow anonymity so that so much of the web looks like what used to be scrawled on highway embankments.
So let me address that a little bit, because this goes back to a fundamental debate, not just about 230, but about the web itself. And there's always been this debate about if all speech is anonymous, you get a lot more voices, but you also get a lot coarser speech, and there's less accountability with anonymity. On the other hand, if you have less anonymity and more accountability, you have less free speech, less ability to use that speech to, for example, criticize government. Okay, so you won't have any use of the speech for criticism, for advocacy of unpopular causes that later become popular, and there's much less privacy if everything has to be attributed. So there's this balance. One approach
I also
is,
think
yeah.
it may be, Mike, it may be a question that shouldn't be answered as a matter of absolute technical mechanism one way or the other. There are circumstances in which it makes sense to probably require people to be identified. But if we have, again, this goes to the challenge that we have a relatively small number of platforms which have substantial market power. I would say it would be a terrible thing if we forced everyone to be identified all the time. That is harmful to people who are in marginalized populations, who feel they need to be able to express themselves in some cases without consequences because they don't think they'll be treated fairly. The Supreme Court has said that there is a right to anonymity, at least in the case of political speech. And so I think this is, there are a lot of things that you're saying that are true, but I don't think we should implement it as an absolute technical measure one way or the other.
Right.
It's worth mentioning also that Facebook has a real name policy. So that's actually, they made a policy decision about that. And you got to say, there's a lot of really bad speech out there on Facebook. So it ain't the solution to all the problems.
And there's at least one case of somebody being criminally prosecuted for violating the real name policy on MySpace. So,
all right. Since we were talking about Facebook and MySpace, I'm going to ask Moshe Vardi to propose his question, which is kind of related to what we were just talking about. Can you hear us?
Yes. Can you hear me?
Yes.
So my big concern is the power that Facebook already has. On one hand, it's not a neutral platform. They basically show us what, you see what Facebook wants you to see. And the other side here is that Facebook controls the speech of about 2.5 billion people. I mean, this is just enormous power. I mean, Xi Jinping does not have kind of power to regulate the speech of so many people. So I was hoping that you guys will have some brilliant solution to this dilemma. I've been tearing myself apart. I don't think you have a solution either.
So one thing that I think the Biden administration is going to be looking into is whether to set up some sort of platform regulation commission. One thing that could happen without a new independent agency, which is what I've heard is a possibility, would be for the Federal Trade Commission to open up a new bureau about platforms where they hold hearings and they collect information, and they help to develop best practices. They require reporting about certain kinds of things so that it creates a mechanism for some accountability. So that's one idea out there that I personally think is more promising than any tinkering with 230.
I think the value of that, the kind of approach that Pam is talking about, is it creates a focus for using a variety of different kinds of policy tools, whether it's antitrust law or consumer protection law, or a whole number of other things, changes in law enforcement strategy. But Moshe, I think to your point also, the good news I would say about Facebook is that there are alternatives, and I will say a lot of my students and my kids think Facebook is for us old people,
Yeah.
and they don't pay a whole lot of attention to it. You know, I'm not saying that solves all of our problems, but as long as we're in an environment where it's possible to create new platforms to enable people to create new kinds of associations, and I think this is where Pam's point about platform regulation matters. We have to make sure that there's a lot of policy subtlety to making sure that is always possible, and probably encouraging it more. But I think that has to be part of the answer. And I have to say, though, I don't think Mark Zuckerberg is more powerful than Xi Jinping. First of all, Xi Jinping devotes much more resource to controlling speech, and certainly has the ability to punish it to a far greater degree than Zuckerberg does.
Yeah, there's the difference between Facebook jail and jail.
Right.
Yeah.
All right.
Moshe, I do want to point out one thing. One of the problems you have with the idea that that you can always start your own platform and let the free market decide is that this is driven by advertising, and advertisers want to be where the people are, and the people want to be where the other people are. And so that's what makes Facebook so sticky. All right. And so you're on Facebook because there are other people on Facebook. Now, next month, everybody could leave and go somewhere else, but that presents another problem. If all the people who are hard right conservatives leave and go to Parler, Parler has its own problems, and it becomes an echo chamber. So it's not just that that Facebook sends you what you want to, what they want you to hear. What's even worse is if Facebook sends you what they think you want to hear. And remember, you're not the customer, you're the product.
All right. I'm going to have two more questions, and that's it. Minas Soba, you're still here? You want to pose your question?
Yes, can you hear me?
Yes.
Great. So actually, there's a lot to discuss here, but I'll just try to pinpoint one quick question. So it touches upon something that was asked before, and something that came up in yesterday's hearings, Senate hearings. So it's the idea about, so I believe Senator Blackburn, she when she was questioning Mark Zuckerberg, she brought up a number of examples of how the platform was being used in different countries to suppress speech or take down some stuff. And she also mentioned that there might be a list that these platforms have that they use to identify specific people and take down their stuff. So I kind of think that this might allude to something that has been brought up in media before, which is it possible to make these companies make their algorithms more transparent to us? And would it be possible to do it in a way that doesn't impact their businesses?
So one thing that governments can do is basically say you have to disclose X, Y, and Z that you don't want to. So an awful lot of the sort of things that governments do is basically, I need you to report about this, I need you to report about this, I need you to report about this, and you have to document this, and you have to document this, and you have to document that. So that's something that governments can do. Now, there's been resistance and will be resistance because they claim that the algorithms are proprietary, trade secrets, and they shouldn't have to give away their trade secrets, and they shouldn't have to do this, that, and the other thing. But you can also do a limited disclosure, right? So not that you have to publish it and put it on the internet, but that there's an ability of the government to audit and to sort of do certain kinds of things to make sure that something that you worry about isn't happening. So you see that with some of these investigations of Google and also Amazon. Are they promoting their own stuff and demoting sort of things that competitors are doing. That's actually been one of the kind of antitrust-like issues. And as you know, there's an investigation, antitrust investigation that's been started against Google. FTC tried to do something similar a few years ago and ended up not going forward with that. But you know, antitrust hearings were held earlier this year, and there are some new activist antitrust theorists out there that are getting some attention. So that's another one of the, again, policy tools that's available.
All right.
I just say, I think this is a really critical ACM question where the ACM has a lot to contribute technically. The question of what it means to scrutinize the behavior of a machine learning system, as people know, is not a settled question. And I really think it's up to, Mina, you know, I think it's up to the computer science community to help show the way about what does it mean to, if the government is going to ask for some disclosure, what should it ask for? And how can it ask for it in a way that promotes greater public transparency, that achieves the regulatory purposes government has? There's only a very few cases, regulatory interactions between regulatory agencies and machine learning driven decision-making processes. We've got to get a lot better at how to do that, and the critical questions there are really technical.
And just to finish on what Dan and Pam said, just real quick, you're assuming that Facebook knows what its algorithms do and knows what they're going to be doing in the future, and they probably don't.
Okay. Jim Hendler is going to get very angry at me. I'm going to allow one more question, and then we're going to call.
I'm all for that. I just want to make sure I say thank you at the end.
Somebody here by the name of DJ, who hasn't given me any more information, has no picture. So whoever you are, it's time for you to ask your question.
So my question is, Sec 230, has it passed any laws that would, I guess the best way to say is like allow the further use of these algorithms, and specifically, like, although it's theoretical, shadow banning and stuff like that?
So I don't think actually 230 has anything to do with algorithms. I think there's a separate kind of regulatory set of issues about algorithms, and certainly we've seen a lot of calls for greater disclosure about algorithms. Algorithms are biased, so we know some things about that, right? If you have facial identification systems that basically only are skewed to white people and skewed against Black people, that's bad. There are lots of algorithms that people question that are used in the criminal justice system about, should this person be given bail, or should they be sentenced to 30 years in prison, or 5 months. So those are kinds of algorithms that there's been a lot of call for transparency, but 230 has lots of problems associated with it, but this isn't one of them.
And just to go on that, the algorithms have two problems. The first is that they don't work, and the second is that they do.
Okay, I think we are at an end. I'm going to let Jim give the official sign off, but I want to thank all of the participants, not only
Thank you, Andy, too,
for giving their talk, but for engaging in the preparation that we had earlier this week.
So then I don't have anything to say beyond thanking Andy more than already has been done. He was really the brains behind getting this going, and I think it's great. And I want to thank the panelists. I want to thank Andy, and I'd like to thank all of you for sticking with us, and keep your eyes out, because we hope we'll do more of these kind of things in the future. And if you have any feedback or anything, send them to the USTPC email address, and we'll take that into account in our future planning. Thank you all, and Facebook claps and all that.
Bye.